Record. Okay, hi everyone. This is workshop 9 for succession law. Hopefully we're all in the right place. And the theme for tonight is intestacy and looking at the intestacy rules. So I guess as usual, we'll start with seeing if anyone had any questions about the readings for this week. And we'll go from there. Now I know we did have one question via email from Andrew about the percentages of the breakdown in for intestacy where there are more than one child, and he very cleverly picked up the deliberate mistake in the notes, which is not deliberate at all. The notes say that where there is more than one child, the spouse is entitled to half of the estate after the spouse's remainder. Schedule 2 of the Act, if you go to the actual original source, says it's a third. So we'll hit that when we come to it. That was a mistake I hadn't seen in the outline, so I'd like to pretend it was just there to get you to find that deliberate mistake, but I must admit I'd missed that as well. Good thing it's not a published book, isn't it? All right. Now I got some background noise, and I will just go and for a moment and get rid of that for you guys. I'll be back in a sec. Okay, back again. All right, so intestacy. It's the situation that the courts try to avoid at all costs, where a will fails or a will isn't present, or what's increasingly likely is where a will is missing. And there's often situations where people just can't find the will. And back in sort of the old days, I guess probably not that long ago now, people used to keep portfolios of documents at the bank with their bank accounts. And I think it's I don't even know if banks provide this as a service anymore, but it's probably a fee for it. But you can keep all your important documents in a central point. And that means if something does happen to you, your executor, or I suppose at that point administrator, can go to the bank and look through your folio of documents, can find your will and so on. Now that doesn't happen much anymore. It's one of those things that sort of it's an old-fashioned things to do and people don't really do. I guess it's one of those things as advocates, it's part of our community education role is to not only inform people about the importance of having a will, but also inform them the importance of having it somewhere that's easily locatable. Because if you're dead, people aren't going to be able to ask you where you've put it. I guess, hopefully is the original signed copy, but you can also back that up by having scanned copies online. So one thing you can do, particularly for people who you've named as executors, is you can have something like a Google Doc or something where you've scanned the copy of the will and you've put it online and you've told the executor, if anything happens to me, it's a shared document and you have access to it. That's probably a sensible backup plan, because in the absence of the original copy of the will, I'm sure the courts would grant administration on a digital copy in those cases. Okay, so that was a bit of a meander around the topic, but the fact of the matter is something in the order of 10 to 30% of all wills are intestacy. And that adds extra costs, delays, and of course when you have to apply for administration, those costs are going to come out of the will itself. So out of not the will, out of the testator's resources. It's a particular problem in the indigenous communities where wills are not very often used at all. So it would be nice not to have to learn the rules around intestacy. It would be nice not to have to go there. However, practically we do, and practically it's something that's probably going to be on the increase. And part of it too, and we discussed this right back at the very beginning, is people don't want to think about wills, and because they're going to be dead at the point that a will becomes important. So it's something that's very easy to put off, and it's also very easy when you're young and don't have much in the way of resources to say, oh, look, it doesn't really matter. However, it can, even if you don't have much in the way of resources, even if you have like a partial interest in a car, it does help the people who have to sort out your estate, and they're not going to be in a very sort of good frame of mind to be dealing with it. So quite often you have like young people who die without a will, and they've got some money in their bank account, they've got maybe a car they're paying off, they're half paid off, and then of course their parents are put in the position where they have to apply for letters of administration and run through the whole intestacy process when they really don't. It would be much easier if there was a will, an executor that just basically left all the property to one person. That would probably be the easiest thing, even if it is that parent. But anyway, this is part of that sort of abstract part of legal ethics and legal responsibility that's community education. And I guess it's part of that thing where you become a bore to people at parties by saying, do you have a will? And nagging people about this, nagging friends and relations and workmates and so on about it. Okay, so the rules around intestacy of themselves aren't bad. Historically, you can see where they come from. There has been some call to have the law reformed in the area, and I've linked you to something that the Victorian Law Reform Commission mentioned, and it's going to be one of those key areas that as we move towards, and I think one day we will get there, uniform succession laws. It's going to be one of those things that's important to clear up. Okay, so let's have a bit of a look at the intestacy rules in the Queensland law to start with, just so we're all on the same page. So we are basically, most of the rules are in the schedule to the Act. So Schedule 2 is distribution of residuary estate on intestacy. And the other thing to be aware of too is there can be partial intestacies. So if a gift fails, for any of the reasons we've talked about this term, it doesn't automatically necessarily go to someone else. It's best to leave the residual to someone. So if you leave 3 gifts to A, B, and C, and then you leave the residual of the estate to C, everything that's left over, then if the gift to B fails, then at least C will receive that, and it won't be an intestacy. So that's one tip, is to actually have someone entitled to a residual of everything else in the estate. Therefore, if it fails, there won't be a partial intestacy, and if there is a partial intestacy, the same rules kick in. Okay, so the big distinction that's made, there's two key questions, and the number one question is, are you survived by a spouse? And the number 2 question is, are you survived by any issue, as in children? Because we couldn't just say children, because people don't know. I don't know. This is some of the drafting in these areas are, let's say, needlessly complex and obtuse. I think the core of this Act was 1958, so it's kind of old. And the actual technical structure, the complexity of the textual structure of the legislation is problematic. So don't see stuff like this and necessarily think that law has to be like that. You can design things in a way that's elegant and reads well and is straightforward. And you'll see in some of the states where they've had more recent law reform, not necessarily with intestacy, but in other areas, there's a lot, the language that's used is clearer and more straightforward. But unfortunately, the one we're using as our model, which is the Queensland Act, is very much from that era of clauses, subclauses, subordinate clauses, Section 1, subsection 2, subsection A, B, subsection C kind of madness. Anyway, so the key questions are spouse or no spouse, issue or no issue. Primarily what happens is under intestacy, the spouse is entitled to a sum of money and the household chattels, which is basically the stuff from around the house, and then the residual is divided up. So a portion goes to the spouse, and we'll talk about the specifics in a moment. A portion goes to the spouse, and then if there are children, the rest is divided up amongst them. If none of those people exist, we're now in the field of where next of kin come into play. So parents, siblings, aunts and uncles. And weirdly enough, in Western Australia, parents get shoved up the order a little bit, and they get divvied up with the children. They get quite high priority. I don't know why. I don't know why Western Australia's unique like that. But basically, we then go to the next of kin, the more immediate relatives, and at some point, the gift lapses and falls to the crown. Lucky crown. And the second part of what we talk about tonight, once we've sort of talked around the law, is what some of the problems these assumptions make. Basically, your family model that the courts have in mind is basically nuclear family, monogamous nuclear family, and children. And increasingly, people and increasingly, people are adopting different family structures, and it has a big impact on the way property is divided up. And Andrew's just asked us about the household chattels and collections. There is case law on that, of what forms a chattel and what doesn't. And there's cases on pianos and things, whether a piano is a part of the chattel. Back in the era when everyone had a piano, and then they say, but this isn't just a piano. This is I don't know what great pianos are, but this is a great collectible piano. Is that part of the chattels or not? So yeah, the household chattels thing is something that does become very divisive. And there's also weird stuff when you look at money. When people start collecting money, like they're like a money collector, and something might be a banknote that's worth a certain amount of money, but it's also worth money as part of a collection. So anyway, but yes, there is case law on chattels, and it does not include collections that are collected for investment purposes. And this is where all the money really goes on challenges to administration of wills. Really, is someone comes in and they're convinced that someone shouldn't get the Persian carpet because it's really, really valuable. At the end of the day, it might be worth $3,000, and the costs of application and sorting it out end up being $7,000. And that's one of the tragic things about wills. This is also, I guess, an area where we should touch on alternative dispute resolution, and things like mediation should really come into play more often. Okay, so back to the rules. If there's a spouse or spouses who survive the intestate, the first fact scenarios that are in the rules are where there's one surviving spouse. They talk about more than one surviving spouse under the definition earlier in the Act. if you are a dependent former spouse, and Megan has just pointed out that there's also a meaning of household chattels in section 34A, which I'm sure excludes strange collections and things as well. I won't get distracted at the moment. Okay, so in terms of spouses, why do they say spouses? Why do they use the plural? We're not Mormons here. We don't recognise polygamous marriages. We're talking about serial monogamy. We're talking about people who are dependent spouses from a previous relationship. And the way we define that is if there's someone who is receiving maintenance, their ex-spouse receiving maintenance. So that makes the first thing that makes the idea of a spouse more complicated. The other thing that makes things more complicated is that the definition of spouse under the Act has been broadened not only by the recognition of de facto relationships, but also the Acts Interpretation Act now allows same-sex couples to be recognised, which is an important step forward in terms of succession law. Particularly, there's been some awful cases in the past where people who are in same-sex relationships and they die intestate, and then the parents who have disowned the person because of their same-sex relationship are entitled to the estate. And there's been some very, very nasty, awful situations where horrible homophobic parents have then grabbed control of the property and excluded the lifetime partner of their child. So fortunately, the Acts Interpretation Act, Section 32DA, has expanded the definition of de facto partner. Where's my Zoom window? I'll just share screen quickly. Okay. That's the relevant section of the Acts Interpretation Act. Worth having a look at, primarily because the idea of what is a spouse, a partner, a de facto partner, is again radically changing. So this is something I think is quite interesting. One or two persons who are living together as a couple. I can't figure out why that's in there. And when you have one person who's living together as a couple becoming I don't get that. I don't understand why it's one or two. Anyway, so one or two persons living together as a couple on a genuine domestic basis who are not married. There's a whole series of things that they take into account. Length of relationship, whether it's a sexual relationship or not, financial dependence, shared property, care and support of children, performance of household tasks, reputation and public aspects of the relationship. Important thing there is that you don't have to have all of those, and they do weigh those up. So you can be in a situation where you live in the same house with someone and you have some kind of sexual relationship with them, and it's possible that you would not be considered a de facto partner because realistically it's not a life partner domestic basis. So you don't, it's interesting that it's a combination of these factors. So it says no particular finding in relation is regarded as necessary. You're not regarded as living together just because you have a common residence. Here's the big one in terms of recent law reform is gender of persons is not relevant. And here's the one, a person is related to family, and it would be a prohibited relationship within the Marriage Act, is not considered a de facto relationship. So if you share a house with a brother or sister, it seems to be kind of obvious that it would think there would be a more elegant way of putting it, but it says there that they're not going to presume you're in a de facto relationship if you're a family member sharing a house with the other person. I would hope we didn't, but maybe it has to be pointed out. Anyway, I'll stop sharing that for a second. All right, so the Acts Interpretation Act helps us out a little bit there. In fact, makes things a bit more complicated. As we're going to come to in a moment, the changing nature of relationships are such that people are not, even those broad definitions of de facto can sometimes be challenged. Anyway, so back to the intestacy rules. And again, these are things that are best served by you reading through them and working through them yourself. If it's just a surviving spouse and no children, they're entitled to the whole of the estate. If there's more than one surviving spouse, then it's divided up between them in accordance to Section 36, which talks about basically maintenance provisions for exes. If they're survived by children, and if there is one spouse, they get $150,000 and the household chattels, and then a portion of the estate depending on the children. So if there's only one child, they get half the estate. If there are more children, they get a third of the estate, and then what's left over is divided amongst the children. And we discussed the chattels before. Now, of course, that's a real pain in terms of setting a set figure is difficult because of inflation. And it means you have to go back and amend the Act every time you change that figure for inflation. So that's another reason why this is quite unsatisfactory. And when you compare it to, say, the family provision laws, where basically they say, oh, well, whatever the court thinks is appropriate, yeah, just do that. I mean, they're very vague. Having this which has a definite number value is a little bit out of step with the rest of succession law. Okay. So then the next section is the multiple spouse rules. If you're not survived by a spouse, issuer entitled to the estate. If there are no children, and you're survived by a parent, it goes to the parents. If you're not survived by the parents, it goes to the next of kin. If there are no next of kin, it goes to the Crown. Bona vacantia. And the Crown's entitled to it. The rules are relatively straightforward. The other thing, I guess, is to look at the definition of children. Or issue under the Act, which again can create problems. Because it's really, if I'm remembering correctly, only blood relatives or adopted children. Let me just quickly check. The definition of issue I just found. It doesn't include embryos. There's case law on that. If you have a lot of preserved embryos, they don't get an entitlement under the will, which is, I must say, an incredibly weird thing to have actually gone to court. Sorry, I'm not very focused tonight. I'll look it up later rather than having you sit there and waste your valuable time watching me flip through the Act. But I'm pretty sure that that stepchildren need to be adopted if they're to be entitled to take under a intestacy. Now, there's also I think the sort of strict definition of children, adoption, and stepchildren also belies the complexity of the relationships people have with dependents in the community. There are people who take on responsibility for people they're not related for, particularly children, who look after them, who don't formally adopt them, and particularly maybe they might be children of a relative who's unable to care for them, and they look after them, and they can end up being left out in the cold. And Megan suggested to be a spouse. There's a 2-year. Can they apply for family for provision? I don't think so under an intestacy. I'm not 100% sure, but I don't think. I think an intestacy is the way the cookie crumbles. Yes. Megan suggesting yes, they can apply. I would have to follow that up. I'd have to check. Not that I'm doubting, but I haven't actually looked at the conflict between those things, and the textbooks, as you know, not all that helpful on that area. Suggesting if someone has needs, so it's disabled or yeah. I guess the first step of intestacy is the grant of administration, and that would then create something that people could apply to. Okay, so are we all okay on the actual technical intestacy rules in terms of the way things divided up? Anything I need to clarify? As I mentioned earlier in the semester, this is a kind of a bit of a no-brainer for one of the choices for exam questions, because you can just provide a series of factual scenarios, get you to go through and divide it up, and as long as you show you're working, like in a maths problem, you show why you've done certain things and made certain divisions, then we're right to go. Okay, so the primary focus of the discussion tonight is why is the law reform aspect, why are people dissatisfied with this? So if I can quickly bring up the what the Victorian Law Reform Commission had to say about it, and I can move all my windows around. So there was a review by the Vic Law Reform Commission relatively recently. I've sent you the link to that. And sorry, I'm going to make you sick with scrolling. And it has some summaries of, admittedly, remember this is the Victorian legislation, it's not the Queensland legislation, but in the areas that recommend reform, they are very similar. They recommend, the Law Reform Commission recommended things remain the same, that there be a hierarchy of next of kin. But they said they would change some of the definitions. So first of all was the definition of next of kin, to make that more inclusive. The second is survivorship, and survivorship is a problem throughout succession law. It's one of those problems that has its roots in legal theory and abstract legal concepts, and is less of and I'm not sure that it serves its purpose well. So we will look at that at some point. I guess when we look at I think we looked at it last week, actually. We looked a little bit at survivorship. But that's the idea, that you have to survive someone to inherit property from them. And the reason for it, so if you die before someone else, you can't inherit property from them, even if you die 1 second before they die. And if there's proof of that, the property can't pass. And if there's no proof of who died and you seem to die at the same time, the legal presumption is that the person who is oldest died first. There's a rather tragic case of a mother and son who jointly committed suicide. And in that case, they decided, because the mother was older, obviously, she must have died first. So why is this a problem? Well, the problem is if you leave something to someone who dies before you, even if they die in the same event, the gift will fail in most cases, or at least if they're older than you, and it won't pass. Ordinarily, the gift would then be passed to their estate. So if you leave something to someone and they die in a car accident with you, it would then go to their estate and then would be passed along with their property. But because of this rule, you have to survive a person, and I think it's 7 days you're required to survive a person for property to pass. The origin of this is a very obtuse common law rule that there can't be a gap in a chain of ownership, that someone has to own property at every particular point and the chain has to be complete. And these decisions all came from this rather strong preoccupation the common law judges had with this chain of ownership. So that's a long sort of historical background to it all. And what it's meant is that for intestacy law, you've got a situation where people haven't got wills in the first place, so they're not going to have actually contemplated survivorship. So you end up with things that are way too complicated in situations where two people die in an event, and just to give an example, mother and father die in a car accident. Father has a will, mother doesn't. They both own property, individually as well as joint property. Where does the property go? Well, if we reform the laws of survivorship, then it would be very easy for the property to then pass to the person who has the will, subject to the complicated division with children under intestacy, but at least the primary property would pass that way. At the moment, there's this presumption that you've got to survive by a week, and that creates all sorts of problems. Anyway, that's why the Commission was suggesting that a change to the laws of survivorship, changing the size of the share and their right to elect to acquire estate property. This is a problem in some jurisdictions have fixed it, but in many jurisdictions, you're entitled to the matrimonial chattels, but not necessarily the matrimonial home. And they want to fix it so that if you don't own your matrimonial home, obviously a lot of people have joint property, and that's easy because the joint property passes to the survivor, so that's okay. But there are circumstances where people are not in joint ownership. The person who dies owns the property, and then the spouse is in the position where they're basically forced to sell the property to pay out the children's shares. So the Law Reform Commission suggested some of that should be fixed as well. And intestate estates of Indigenous people. Again, it happens way too frequently that Aboriginal people are intestate, and Aboriginal families tend to be much more complicated and not bound by strict definitions of parenthood and blood, the way that Western families are necessarily. I mean, plenty of Indigenous people, of course, do live in nuclear families, but there are also a lot of people who live in families that have children drawn from different origins, who are children of cousins, children of friends and things, who end up in those family groups. And the current intestacy law forces you to basically make a ruling between the blood relatives and the non-blood relatives. Okay, so look at that very briefly. The other thing I suggested we have a look at this week, and is some of the recent, although there might be more recent data coming through by now, from the Australian Institute of Family Studies on family trends. And again, looking at how some of the assumptions that were made in the 1950s about the way in which families operate and who supports who are not necessarily true today. So, I mean, yes, couple families are still common, but they're not the most common family form. We've got an increase in one-parent families. Blended families are more common, and again, the preference for blood relations under intestacy law can create problems when someone has been treated as and effectively are the child of a particular person who they're dependent on. And the whole adoption thing is sort of, people don't often go through the formal legal adoption. Sometimes they do, they'll legally go through the process. But more often people will just have kids who they raise as their own, whether they're stepchildren or whether they're children of someone else. Grandparent families are not common, but they are strong. They are represented in the field, and again, that's a situation where grandparents take over the primary parenting of children. And there's a discussion in the paper on families with fuzzy boundaries. People who are living separately and apart, living apart together, where people are not cohabiting a household, which is really the definition of de facto partner really does talk about sharing on one property. And this report suggests that there's increasing numbers of people who live in effectively a de facto relationship, but they live in different places. Children who have multiple homes, not necessarily a problem for us in terms of intestacy, because they would still be recognised. But the overall, what the research is suggesting is that we can't really make assumptions about family being mum and dad and kids the way that we used to. And Richard has pointed out it's 30 days that you must outlive. Sorry, I have got awful headache tonight, and I am not firing on all cylinders, as you probably noticed. But we will get through. We will muddle through these 30 days. You're quite right. For survivorship. All right, now I have to figure out how to stop sharing the screen and get back. Okay, so sorry that was all a bit of a muddle tonight. It's probably time for a few questions if people want to ask them, and I'm sure some of our very capable contributors will probably be more on the ball than I am in getting an answer to you. So please ask away. But the important thing, I mean, this section this area of the course is really a procedural one, and it's a case of going through the legislation and making those divisions. What else? We're heading into sort of the last couple of weeks of the course, which you may say hooray. The last 2 weeks really do focus on personal representatives, and we'll come back to the family provision stuff again a little bit in the last workshop, where we'll look at some. So next week's workshop is, our focus is to create a guide for personal representatives, so executors or administrators. And what I'll probably do is create a shared Google Doc, and that's a good format for us to collaborate on. And we might just do that in class, and we'll go through and we'll sort of rough out the sorts of things you might want to put in a guide for personal representatives. So it's a really useful exercise to go through, because in defining something for a layperson, you've got to be comprehensive. You've got to make sure you put everything in there. But you've also got to be conscious that you can't just throw the entire act at them and say, "I'll just read that and that'll tell you what you need to do." So it's actually it's one of those things that teaching someone else and informing someone else about an area is the best way to be sure you know about it yourself. And that's how we'll consolidate a lot of our knowledge around personal representatives. We'll go through, and I'll just create open permissions, and then everyone can get in and add components to it. So that should be at least more interactive, and get everyone involved. And the final week, we're going to look at the workshop is based on the challenges to wills, and I haven't created the characters for that yet, but I'll create some sort of case study characters of people who want to challenge the will. And the focus on that week is really going to be on forming an argument. It was a real advocacy issue. It's not just under the family provision sections. It's not really black and white, right or wrong. It's how you frame an argument, and that's a good opportunity to sort of exercise some advocacy skills. Okay, and Louise has a question. Scott, did you say the exam questions are all scenario problem-based questions? They're all modifications of workshops for this subject. So each of them, I've taken one of the workshops that we've done, so it's not something that's coming out of left field. It's something you've done before, and I've modified it or changed it somewhat, but it should be still quite recognisable. So, for instance, in the intestacy workshop, the original plan was to get you guys to create scenarios to use, but of course, with a very small number of people in the class, I was a bit ambitious with some of the tasks I set. So, if I was to, as a totally questionable example, turn that into an exam question, what I would do is I would then put some set facts in there and say, divide that and comment on it, and how would an intestacy provision apply there. The problem questions, they're the questions that are in you're asking about in the weekly ones. There's some short problems. Honestly, I left those in the notes because I'm only looking after this subject for a term, but I don't find those terribly useful, because basically they're just a case of picking the relevant the case that it's similar to and applying the case. And I know a lot of law questions are like that. I don't think you learn an awful lot about that things, except, what cases are those things similar to. So no, there won't be those. They won't be those at all. They'll be much more in line with what the workshop questions are. Yeah. I know a lot of law subjects use those kind of problem questions, but honestly, they are extremely difficult to score well on. Primarily what happens when students have problem questions and exams, it reduces their overall grades quite significantly. So a lot of law academics think that's a good thing because they get to separate the wheat from the chaff, and because they think they're tough. But basically, it's extremely difficult to take something where you say, well, this is like this case, and to turn that into high distinction. It's only more than a pass. Okay, sorry, I'm meandering again. And is there 4 questions we need to do in the exam, 10 marks each? I believe there are 2 questions worth 20 marks each, with out of choice of 4. But that's on the agenda for that's on the agenda for next week. That's on the agenda for week 10 is the discussion of the components of the exam. I have marked your assignments, which were, generally speaking, pretty good. Read some really interesting pieces there. And I haven't uploaded them yet. I will probably upload them in a moment. I'll upload them this evening, and with the rubrics and marking guides. Now, because of the time allocation for grading, you may be aware that we have we're not allocated very much time for marking. I've tried to provide concise comments and useful feedback through the rubrics. However, I am available, particularly in a class of this size, to have a talk about your assignment as well. So don't think that if you get my comments and you just sort of don't understand them or whatever, that's it. That's it. You just have to figure it out for yourself. We can arrange a time. I don't mind having a chat about it and talking about things in more depth. That's one thing about it. Please don't feel shy about asking to have more of a chat about your essays, particularly because I know we don't provide a lot of support for things like essay writing and style and legal assignment writing in our program yet. I'm working on embedding more things there, but I know we don't have a lot of things that face-to-face students won't have access to. And the other thing about yeah.
Sorry. Hi, it's Lauren Button. Sorry to interrupt. At the beginning of this lecture, I clicked on the assignment page to check if I'd received my mark yet.
Yeah.
And it came up with a box saying submit for marking. Did you receive my assignment?
Yeah, I have, but it wasn't submitted, but I could still get into it anyway. There were 2 of them that weren't submitted.
Oh, okay, good. I just freaked out because I did it a week early, and I just thought, oh no.
Yeah,
right.
I think there might be an extra step. I mean, this version of Moodle is quite terrible, but I think there's like another step you can upload a draft and then you have to finally submit it or something. But the good thing is I could see what you had submitted and I just downloaded that.
Yeah. Oh, excellent. Thank you.
The other thing when it comes to having a look at the comments on your papers is some of you got quite good marks for your papers. Although I'm not the kind of person who gives people 30 out of 30 or whatever. But I've tried to, even when you've done really well, I've tried to come up with ideas of things to look at that might have been interesting or might have been extra things that you could do as advice for improvement. Don't think that just because I've put comments there that I've somehow marked you down and that you've lost marks because you haven't done X, Y, or Z. It's purely there because I'm trying to provide you with some feedback to think about in terms of what you might have done or how you might improve what you do. And that's a kind of a subtle distinction, but sometimes people won't look at the grade they've got. They'll get like a distinction or a credit or whatever, and they'll get a good grade. And then because I've put comments on, they'll say, but I did this, and you marked me down for it. Comments are just there for things for improvement, but you grade it against the marking criteria that's on the rubric. Yeah. Overall, as I said, you guys did pretty well. Okay, so is it only a 2-hour exam? I believe it is only a 2-hour exam. It's only a 30% exam. Is it 30 or 40? 40%, and 40% exams should be an hour and a half under the formula for exams. I know law lecturers are very naughty and they tend to make you do 3-hour exams even for smaller components, but honestly a 3-hour exam can only be set for where there's 100% of assessment is an exam. So technically speaking, if an exam is 100% of your grades, which it shouldn't be anyway because that's ridiculous, it's a 3-hour exam and then it's broken down. If it's a 50% exam, it's an hour and a half and so on. So anyway, it's a 2-hour exam. Any other questions? I mean, we can talk about the exam more next week, and I'll try to avoid giving hints and things. Because I've been told that we're not allowed to do that. We'll see how circumspect I can be, whether I should hit the stop recording button at any particular time. Okay, guys, so sorry it was all pretty confused tonight. I think we covered everything, and thank you very much, guys, for looking things up and helping. Hopefully I will not have this headache next week, and I will be firing on more cylinders. And otherwise, send me an email, drop me a line if there's anything in the meantime. Otherwise, I'll see you next week. Okay. Good night, all.